Florida is recognized.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
The gentleman from Florida is recognized for as much time as he may consume.
Thank you, Mr. Speaker. At the beginning of this, members read aloud the Constitution of the United States from the floor of this very chamber. That reading, of course, included the Bill of Rights, those first 10 amendments so vital to protecting the individual freedoms of all Americans. Today, I urge my colleagues to support the passage of H.Res. 196, a bipartisan resolution affirming our support for the Sixth Amendment to our Constitution. The Sixth Amendment guarantees the right of all Americans to a fair trial. It also reads that in all criminal prosecutions, the accused shall have the assistance of counsel for his defense. We all agree that the right to counsel for anyone accused of a crime is the foundation of individual liberty. It is essential to the rule of law and the basic principle that in America, the government cannot take away any citizen's freedom without a fair trial. H.Res. 196 is a bipartisan resolution reaffirming the support of this Congress for the Sixth Amendment right to counsel at a time when this right is too often trampled in our modern-day justice system. 50 years ago, the U.S. Supreme Court recognized in the landmark case Gideon v. Wainwright that access to quality legal representation is essential to a fair trial, and that even Americans too poor to afford an attorney have a right to counsel. This landmark opinion held that states and localities have a Sixth Amendment constitutional obligation to provide counsel to indigent defendants. Yet a half-century later, the reality is that we continue to struggle to honor the right to counsel upheld in Gideon. Reports by the Department of Justice, the American Bar Association, the Constitution Project, as well as innumerable law review articles by top experts in criminal law, have revealed how legal representation for indigent defendants often has been undermined by crushing caseloads, inadequate funding, and other obstacles. It's been estimated that 80 to 90% of all persons charged with a criminal offense qualify as being indigent and cannot afford an attorney. The American Bar Association, in its comprehensive report, Gideon's Broken Promise, concluded that, and I quote, "Thousands of persons are processed through America's courts every year, either with no lawyer at all or with a lawyer that does not have the time, the resources, or in some instances the inclination to provide effective representation. All too often, defendants plead guilty even if they are innocent without really understanding their legal rights or what is occurring." In this time of limited resources, the right to counsel has also been undermined by cuts to funding for indigent defense. These cuts have eliminated training programs to keep lawyers informed of criminal justice best practices and have limited the ability of lawyers for indigent defendants to access investigators or experts essential to adequately representing their clients. We pay a hefty price when we fail to uphold the Sixth Amendment of our Constitution. It's not uncommon for indigent people without an attorney to sit in jail for weeks or months, causing the loss of a job, a home, and in some instances the loss of a family. Failing to provide adequate counsel to indigent defendants can also lead to costly extended pretrial detentions, costs associated with appellate litigation, costs for appellate defense counsel, prosecutors, and appellate courts, incarceration costs of indigent people during the appeals process, and other unnecessary costs. From our unsustainably high rates of incarceration to the lives of families torn apart by unnecessary jail time and wrongful convictions, Congress can't afford to ignore the economic and moral costs of this crisis in our criminal justice system. Our nation's failure to uphold the Sixth Amendment has resulted in bloated prison and jail populations at the state and county levels, which hold more than 2.2 million people at a cost of $75 billion per year. An additional 5 million people are on probation, parole, or supervised release. And yet, Mr. Speaker, despite all the comprehensive reports, all the law review articles, and all the stories reported by the media, the fundamental right of an indigent defendant to adequate counsel remains at risk. The situation is dire. Look no further than a recent determination made by the Florida Supreme Court, allowing the Miami-Dade Public Defender's Office to withdraw from 21 criminal cases because of excessive workload and underfunding. In fact, it was found that approximately 400 felony cases were being assigned to the average public defender, and public defenders in third-degree felonies had as many as 50 cases set for trial in a week. These facts provide us with just a glimpse into a growing crisis within our criminal justice system. There is no question that states and localities are struggling to provide adequate and well-resourced lawyers to indigent defendants. Ensuring that all Americans, regardless of their financial resources, have access to a lawyer is essential to our system of justice. Our failure to uphold the Sixth Amendment undermines the premise that in America, every person has the right to a fair trial and is presumed innocent until proven guilty. HRES 196 is a product of bipartisanship. I would like to thank the House Judiciary Committee Chairman Bob Goodlatte for his support of this resolution and the Sixth Amendment right to counsel. I would also like to thank Congressman Steve Chabot for all of his hard work on this resolution and for working to ensure that indigent people in the criminal justice system are adequately represented by counsel. I also want to recognize Ranking Member John Conyers and CRIBE Subcommittee Ranking Member Bobby Scott for their support of this resolution. And for my colleagues who are as concerned as I am about the state of indigent defense in America, I invite you not just to support today's resolution, but to join me as a co-sponsor of H.R. 3407, the National Center for the Right to Counsel Act. This legislation aims to improve financial and training resources for state and local public defense systems and encourage the adoption of best practices for the delivery of legal services to indigent defendants. The bill would equip localities with more tools to implement their own indigent defense systems and meet their constitutional obligations as defined by the Supreme Court in Gideon v. Wainwright. I look forward to working with colleagues on both sides of the aisle on this legislation. Mr. Speaker, the first step towards solving any problem is confronting it, and that's why I'm so pleased to have HRES 196 on the floor today. The Supreme Court recognized in Gideon that, and I quote, "The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours." It is long past time that the House of Representatives engage, debate, and develop strategies to assist the states with improving the delivery of indigent defense services. I urge my colleagues to support the right to counsel enshrined in the Sixth Amendment of the Constitution and to join me in